Hey, Lewis, I've got these contracts. Got contract A, contract B, contract C, contract D. But I don't know what on earth they mean. What's the difference?
Okay, well, by incredible coincidence, I happened to prepare a slideshow just on that issue.
Really?
Yeah.
I would never have thought that about today.
Yeah, amazing, isn't it? Yeah. Okay. Let's fire it up. Okay. I'll fire up the slideshow.
You don't know anything about computers, do you? Hey, kids.
Some IT stuff, right?
Okay, so let's begin then.
Okay. So I guess our members and everybody can see this. Tozen Daigaku work contracts and how employers screw you over.契約形態でやられちゃった. Okay, 次. Okay, first of all, I want to start with a very important issue is that as we go deeper into this, please don't use the word contract worker. Like I hear this word all the time, contract worker, and the equivalent in Japanese, keyaku shain. And the reason I don't like to use this expression is because it's ambiguous. It can mean many different things. Some people use it to mean a fixed term contract. Some people use it to mean a gyomeitaku outsourcing contract. Others use it to mean part-time. What we're going to talk about today is basically any type of work situation, you're under some type of contract. So it's kind of misleading to separate some of them as a contract worker. And later we'll get into whether contract is a verbal or written agreement. Okay, this is still visible, right?
Yeah.
Okay, tsugi. Okay, so these are the types of work contracts or agreements that we're going to go over today. And okay, a contract in Japanese keyaku. There's also agreement. Basically, a contract is an agreement. It's a promissory note by two parties. Okay, and there are business contracts. There's also labor contracts, and that's one of the big key themes of today is that they're very different. The idea behind a business-to-business contract or just an agreement between two parties, it could be like an agreement between neighbors about who's responsible for a tree falling on a house or something like that. There could be exchange of money or something like that. That's governed by commercial code and civil code, and it's basically two parties agree to something. That's it. Employment and labor contracts are very different because there's specific laws that restrict what kind of contracts are allowed. And that's because the way in Japan, the way Japanese labor law sees it is that the worker is economically and socially much weaker than the employer. Employer has, often has many more than one employee. They're often a company or corporation with access to huge amounts of resources. And they're also not actual living human beings, although I know legally they're a judicial person and all that. But so it's very important, first of all, if you're on a contract, that you know whether it's a business agreement or a labor agreement. Okay, and also I want to point out the difference between keyaku, the word keyaku, and keyaku sho. Keyaku sho is a written document. So it's a contract in the sense of a physical document. Whereas keyaku, it could be either one. It's any kind of agreement, written or verbal. And we'll also talk about that. So today, these are the types of contracts we're going to talk about. The first, and you see the top two are gyomu itaku, and the bottom three are rodo keyaku. So the top two, gyomu itaku, there's going to be gyomu itaku. Yeah, and gyomu itaku is a type of outsourcing. The top two are business-to-business contracts. And this is something that a lot of employers, they put their workers on business-to-business contracts so they're not subject to labor law restrictions. So like GABA is a very famous case that the teachers at GABA, they work and they teach just like at other schools, but the company considers them independent businesses and therefore not protected by any of the labor laws. So the top two are Gyomitaka contracts. The bottom three are Rodo Keyaku, and these are labor contracts or employment contracts that are subject to all the labor laws or most of the labor laws. And we'll get into the differences between the three types there. One is Hakken, one is Yuki, and one is Muki. One is Yuki Koyo and one is Muki Koyo. Okay, Sigi. Are verbal contracts valid? This comes up a lot. Both management and often members sometimes think that maybe verbal contracts are invalid or that it was just a verbal contract. Now it's true, a written contract is better, but the only reason it's better is because you can prove what was agreed upon. Verbal contracts are valid under the law. In fact, most workers in Japan have verbal contracts with their employers. There's an understanding. They talk about it verbally. Okay, you work here, I'll pay you, 1,200 yen an hour. That's it. You bust tables or something like that. That's just as valid. The problem is when there's a dispute or something goes to court, the employer and the employee don't always agree on what was agreed upon. And so then there's dispute. So of course, it's safer to have a written contract because you know what's in it. And there's no dispute because both sides hanko it, put their seal on it. And it's much clearer that way. A lot of people say a verbal contract is not worth the paper it's not written on. So that can be true if there's disagreement about what was written. But if you both agree, and I've had situations where management agreed, yep, we agree to that, then it's just as valid as any written contract. Okay, and in Japanese, these are called, keyaku sho is a written contract, as I said before, and the other is called the koto keyaku. That's a verbal contract. Hey, Sigi, you have a question? Go ahead.
Yeah. So with a verbal contract, are there any big major cases that you can think of it sort of being disputed?
I mean, one of the things about verbal contract in a work situation is that, let's say there's a verbal contract, a company hires, 3 administrative workers, like secretaries or something like that, and they pay them the same amount every month. Now, if they pay them the same base pay every month for 2 or 3 years, it's going to be hard for management to argue that they didn't agree to pay that amount. Like, why, oh no, we only agreed to half that. Then why did you pay twice that amount for 2 or 3 years? So in that sense, it's not so common. To be honest, I don't know about a court case where there was a big dispute. I know from, as a union organizer, like in our cases at Tozen Union, that there are often times where there's dispute about verbal contracts. However, a lot of Japanese employers, they believe that Westerners or foreigners in general have to have a written contract, and so they make a point of making a written contract, even though they wouldn't normally for Japanese staff. And it's kind of true. A lot of Westerners do expect a written contract. They feel more secure about it. So, yeah, sorry, I don't know any specific court cases. I could look that up. But
okay. And sort of kind of if these things are debated, can a kind of recording of maybe like this verbal contract be used as evidence?
Yeah, absolutely. Like if you happen to have recorded the conversation where they promised to pay you a bonus twice a year, and then later they claim they never promised that, and then you pull out the recording, then you can, in most cases, you'd be able to use that in court, and it would help to establish and demonstrate that there was a verbal contract to pay a bonus twice a year. So you're good. Hey, Siggy. Okay, now we're getting into the nitty gritty. Okay, so this is, remember I told you at the beginning, the first contracts we're going to cover, and the way I put the order of these contracts is from bad to good. So this is starting with like the worst contracts, and that's Gyomu Itaku. This is basically where one business outsources a certain operation to another business. So, or it doesn't even have to be one business. So let's say you want to renovate your kitchen or remodel your kitchen. You might hire some kind of construction company to renovate your kitchen. Now that would be between you and this construction company. Okay, now gyomitaka, there's several types of gyomitaka. The first one we're going to talk about is ukioi. And ukioi, the most important aspect of this is that it's a promise. An ukioi contract is a promise to produce a finished product in exchange for monetary remuneration. So like I said, the kitchen, they finish the kitchen and you pay a certain amount. Okay, and this is, you see where it says Article 632? Yeah, Article 632, that's from the Civil Code. So the articles I'll be talking about, a lot of them are from the Civil Code, or minpo in Japanese. Okay, so I gave some examples underneath it. So a construction company promises to build, let's say, an upside down house by April 1st, 2022. Now notice there's an end date, like a deadline, and then there's a finished product. And you can see the finished product in the picture on the bottom left. And in exchange, that construction company will be paid a certain amount by whoever ordered the upside down house. Don't ask me why they ordered that, but okay. Or let's say a publisher promises to translate the sagas of Icelanders into Hosa by September 24th, 2022. Okay, so that's a finished product. It's not an ongoing thing. It's like, okay, it's start and finish. They finish by a certain date, and then the publisher pays the translator. Okay, so this is gyomitaka ukioi. And again, because it's gyomitaka, it's not covered by labor law at all. Okay? Hey, Sugi.
So,
okay,
can I ask?
Sure.
So, because the focus is on the end product, what kind of requests or what kind of points or structure or instructions can the contractor give to?
That's a good question. So like, let's say I order the upside down house. So I think you're asking, so how much detail can I go into it? Well, of course I can say I want it yellow and red with red roof. I want it, facing this direction. I want this and that. Now, when it comes to the point of the personnel involved, that's kind of a line you can't really cross. Nope. So in other words, if they have let's say they have 10 builders, okay, I know nothing about construction, so I'm just guessing, but let's say they have 10 builders, and they also have to get supplies. So that company has to buy supplies. So I can't intervene in their business to say, no, you shouldn't use that supplier, you should use someone else's supplier. No, these 10 people are not good. I want you to hire my nephew, and stuff like that, right? So there's certain a kind of a line, like kind of a social norms line. It's not like written in the law, but it's understood that you're asking for a finished product with certain specifications. How they reach that finished product with those specifications is up to the construction company. Okay. Yeah, and the same that with the translator. Okay, I want the entire Sagas of Icelanders translated, and I might have certain requests about how some things are translated into Hosa, but I can't, like, if it's to if the translator goes and gets help, or even outsources again to someone else, as long as that translator, as long as she brings to me the completed works with whatever specifications I listed, she's fulfilling the contract.
So you can give the outlines on sort of what you want the end product to be.
The specifications, you can say, this is what I want.
Yeah.
But how to do it, that's up to them. Right?
Yeah. So the style, the method, like maybe what products are used or how.
Who. Yeah. Now it gets a little tricky when it's about time. Like let's say I did a ukioi contract with a construction company to renovate my kitchen because my kitchen's old and musty and I want it all renovated. Okay, so normally like the construction company can decide who to send, how to do it, what tools to use, what suppliers, but they can't decide when. Like I can say, and you can only come during the day. You can't come in the middle of the night with a jackhammer, right? I don't know if you use a jackhammer in consumer innovation, but you see what I'm saying? Like there are reasonable specifications like that, right? But I can't, again, like I can't say, well, I want my niece to be hired, or I don't like that guy. He looks at me funny.
Yeah.
Can you not bring that guy?
Yeah.
That would be crossing a kind of a line. Again, it's not explicitly written in the law, but these are the kind of understanding about how these contracts work.
So you can't do anything that kind of almost directly interferes with their business.
Right.
You can only
say what you
the
want.
Products.
Right. Like I want a marble surface, and I want, like a certain filter on the faucet, and I want, dish racks like this. And you can say anything you want about what you want in the end as the end product.
Yeah.
But, or with the translation, you can say I want it in Comic Sans or something like that. But how they get from point A to B, that's up to the ukiyo-e in.
Okay. So we've got a question here
already. Wow.
Yeah. Regarding Gyomu Itaku, what regulations or laws regulates
disputes?
For example, if the end product or deadline is not met, then the provider gets 0 or half, or is it like renegotiated?
Okay, well, first of all, understand is that ukiyo-e is in Minpo, like I said, Article 632. Now, if there's disputes, then like ultimately it's going to be a court. Like, did the construction company actually provide the finished product? And these are very common in courts. Like even just waiting for my cases, I see these kind of cases all the time where somebody promised a certain thing. Like, let's say I hired somebody to, I don't know, like build a garden in my house or something like that, or build a shed or something like that. And then I'm not happy with the product. And so I claim that they failed to fulfill the contract. And then those things end up in court. Personally, I don't know of any particular regulatory body, although there is like, what's it called? The Fair Trade. Sorry, I'm blanking. There's like a Fair Trade Association.
Like Trading Standards Act almost.
No, I mean, there's an agency that deals with fair trade, and there's also consumer protection agencies. So there's that. But ultimately, if there's a dispute about whether the product was provided or not, then it's going to end up in court.
Okay.
Okay, cool. Okay, so we're going? That's Sigi?
Okay.
Okay, now the next type of Gyomu Itaku contract is called inin. Okay, inin is different from ukiyo-e in that it's not a finished product. It's an ongoing job, an ongoing process. Okay, so this is the most like, the thing that first comes to my mind is hiring a lawyer. So Tozen, we hire lawyers all the time. And the plaintiffs, like, let's imagine that 3 Tozen members want to hire attorney Shoichi Ibusuki, like our lawyer, to represent them as plaintiffs in a civil case against Kanda University of Foreign Studies, let's say. For example, okay, in such a very hypothetical case, they would sign a letter of engagement or power of attorney called ininjo. This is called an ininjo. Jo just means letter. So the inin is this entrusting, this ongoing process. Ukiyo-e again is a finished product. The construction company or the translator takes on the job of finishing a product. When you hire a lawyer, you're not hiring the lawyer for a finished product, believe it or not. You're not hiring them for like to win. So if you don't win, you can't claim, give me back the money I paid you, right?
You're paying them for the service.
Yeah, you're engaging them for an ongoing service, right? And now, of course, lawyers' contracts almost always have an article or a term that says, if you win money, the lawyer gets a cut. And that's just part of the overall contract. But again, you're actually hiring them for the ongoing process, okay? This is also true for like if you hire someone to handle like trade for your company, okay? And we will get this in a second. Like there's inin and there's also jun inin. and these are actually technically two different things. Anything that, well, I'll get to it in a second, but so hiring a lawyer or hiring a trader or like at a
Eikai were hiring people on the Gyomutaku contracts.
Yeah, I mean, they would claim that it's inin or jun inin. We'll get to jun inin in a second. Yeah, they would claim that it's gyomitaku. Although there's a reason why that would not be inin, and I'll get to that in a second. Okay, I think I'm not exactly sure, but I think. Okay, that would be jun inin. Okay, so it's the difference between inin and jun is very subtle, and so I'd like to talk about something called horitsu koi. Oh, and before I get to that, inin is Article 643 of the Civil Code, or minpo. Okay, tsugi. Okay, yeah, so gyomitaku jun inin. Like I said, there's a difference between inin and jun inin. Now this jun, you see the kanji on the bottom right. What does that mean? This is you see this in jumbi and other words. It means quasi. So basically, the wording is exactly the same as the previous inin, but it's agreed to quasi-ly. Apparently, that's actually a word. Surprise to me, but delegate, entrust, or commission. And this is Article 656. So it's basically exactly the same as inin, but it's quasi. And what it means by quasi is this concept of horitsu koi. And I'd like to go to that. Horitsu koi. Now I translate this as legal transaction. Okay, if you hire a lawyer or if you hire a trader or there's a legal transaction, it changes the legal status. So if one of our members hires Ibuski, what happens is there's a change to the legal status of things or people. In this case, Ibuski becomes the plaintiff. Legally, the Ibuski, whatever Ibuski writes, is that plaintiff writing it, our member. So you see there's a change of status. Or if I hire someone to procure items, meaning use my company's money to buy stuff, there's a legal change in the status, meaning the possession of those supplies changes from the supplier to my company. Okay, so there's a legal change of status. Okay, so the jun inin does not involve horitsu koi. Jun inin is not horitsu koi, it's these other things, like just normally you hire someone to do this ongoing work, but there's no special change and you're not buying or selling anything, you're not representing legally somebody. So there's no horitsu koi involved, so it's jun inin. Now, of course, this is a problem. This whole gyomitaku thing is a big problem because many employers don't want to have to comply with labor laws, so they put people on these fake inin or jun inin contracts. In this case, jun inin. Okay, good. Good idea. Okay, just tsugi. Okay, now finally we get to proper rodo keiyaku. Okay, rodo keiyaku is labor contract or employment contract. And there's several types, and I'd like to start with the least good type, which is hakken. Hakken is often translated as dispatch, but as an American, it's more commonly called like temp or temp agency contract. And what this is one company sends you to another company. Okay, now there's usually a hakken gaisha, which is like a dispatch agency or a temp agency. If you work for a hakken gaisha, that means the hakken gaisha is your employer. And they send you to a different company where you actually work. And it could be like for a year at a time or something like that. And there's a lot of problems with this, but this is something that was, yeah, and about dispatch, this was not always legal. In Labor Standards Act, Article 6, that's Rodo Kijunho Dai Rokujo. Yeah, you notice I put Labor Standards Act, Article 6 and 1986. And why did I put it that way? Article 6 of Labor Standards Act is the heading is elimination of intermediate exploitation. Now, what this says is that no person may, as a business, profit off of intervening in the employment of others. Now, before 1986, it didn't have that green part. It was just, you cannot broker employment. You cannot get in the middle of like a worker and where they're going to work and then profit off of it. It was understood. One of the things it's important to understand in Japanese labor laws, there was kind of a quasi-Marxist basis in the sense that it was understood that hiring a worker was exploitation. And exploitation was considered maybe a necessary evil, but it was illegal to do this intermediate exploitation, shukansakushu. In other words, it was illegal for someone to get in the middle, not really contribute anything, but just shuttle someone over and take some money in the meantime. This was actually illegal based on Article 6 until 1986. Now, what happened in 1986? 1986, this last part was added, other than where permitted by law. And a new law was enacted called the Rodosha Hakenho, or Labor Dispatch Act, or no, I'm sorry, Worker Dispatch Act, I think it was called. And this allowed this kind of intermediate exploitation, still considered intermediary exploitation, sorry. It allowed it in certain industries and under certain rules. And one of those rules is that a company couldn't use dispatch more than 3 years, and the industries were limited. Well, like everything since the 80s and 90s, the labor law has gotten worse and worse and worse. And so the industries permitted to use haken became more and more numerous, and then the restrictions became weaker and weaker and weaker. Until now, it's basically almost any industry can use it. And the restrictions, there still are restrictions, but they're very, very weak at this point.
So was there something that happened in 1986, 1985 to cause this change? Do you know?
Well, I mean, the Liberal Democratic Party, of course, was in power. And I don't know the history so well, but of course, as always, the business federations in Japan, currently Keidanren, of course, would always lobby for more freedom to do this kind of stuff. And then and then after 1986, all these major dispatch companies came up. So it was a real, it's this constant struggle between business and unions got weaker. In the 1980s, there was the bubble era, the bubble economy. Everything was really getting richer and richer. And there was not that strong labor activism. It was kind of starting to weaken. And in the 80s, they privatized Japan Railways, and all kinds of things happened. So it was definitely a march backwards that is continuing for dispatch.
Yeah. So you mentioned that there was almost a time limit, or previously there was a time limit.
Yeah, 3 years. Yeah.
Hasn't that changed? Like if you're outsourced to a company for 5 years now, you now work for them?
Well, no. Okay, what it was before was that after 3 years, the place to where you were hakened, to where you were dispatched, had to offer you a full-time job. Full-time, like a regular job.
Okay.
Okay. That's gone, but there's what it is now is that like the dispatch company cannot send the same person more than 3 years.
Okay.
Before it was the same company. There's two things. There's haken moto, the dispatcher, and then haken saki, the dispatchee, the company that hires a dispatch. And it used to be that companies could only use this as a temporary measure. But now they can use it as a permanent measure. They just have to rotate the people, which is actually worse than it was before. So, okay. Yeah, the corporate media tries to make it sound like dispatch is great and there's so much freedom, but it's not great. There's a lot of, there's almost no job security. And in Japan, it's considered very low status. There's a lot of trouble, like even bullying between regular direct hire employees and those who come as dispatch workers. So.
I was going to say, isn't that common in quite a lot of countries.
Yeah, maybe. Yeah. I'm not saying it's unique to Japan or anything like that.
Yeah. We do have another question.
That's great.
Same person again. Our favorite.
Okay.
Assuming a Gyomu Taku in with some cut upon winning.
With somewhat?
Sorry, I've lost the chat now. So assuming a Gyomu Taku in with some cut upon winning.
Oh, you mean if it's a lawyer? I guess it means if the eating contract with a lawyer and and a cut on winning upon winning. Yeah.
Okay.
It's called a hoshu. Yeah.
The problem is the work took 20 years instead of 1 year. Is there any way to seek some compensation due to an extended operation cost, or?
Wait, the job took 20 years instead of what?
So, for example, if someone says, okay, well, I think this is kind of expanding on like the if a job ends up taking longer, and so you have to renegotiate and stuff, but you get sort of the result you want. For example, maybe a lawyer. If so, you win, but after they promised you 1 year,
it took,
can you be compensated?
You mean sue the lawyer?
Yeah.
I mean, you can sue the lawyer. Like one thing, it's important what is written in the eating contract, right? What exactly was written? Is there a time limit? Does it say? I mean, for the lawyer, it's very unlikely there'd be a time limit. But let's say you had eating for some kind of. What?
I've worked up the. Sorry, I didn't completely understand. So it's one of these ones where I think, lawyer, and when you win, you pay some cut to the lawyer.
Hoshu, right? Yeah. But first of all, I can't imagine a lawyer's contract that says this will be done in 2 years or 3 years or even 5 years, because there's no way to know. But so what would matter is what the contract says. Also, if there's a violation of the contract, is there a term in the contract that has what's called iakakin, or like a penalty for not fulfilling the contract? And if there is, or even if there's not, you could sue if you believe that one partner of the deal, or like who you commissioned for this job, failed to fulfill the contract, but you'd have to show that it caused you financial damage or other damage. You'd have to demonstrate that in court sufficiently to win something from it. So again, it really matters what is in the contract exactly. I mean, lawyers, I mean, in my experience, they would never promise, first of all, to win in the contract, and I've never seen a lawyer's contract that promised that it would be finished in like 5 years or 3 years or 2 years or something like that. So, because there's no way to know. Right?
What about going the other way? Can they say, you'll probably lose this one?
I mean, I doubt that if they thought that, they probably wouldn't take the case, but and they certainly wouldn't put it in the contract. I mean, so.
Okay. So extra comment on it was just 1 year is just expectation, but things were not going as expected.
Oh, in a lawyer's case?
Yeah, so maybe it's just like a phrase maybe thrown out more than sort of.
Well, one thing about when you hire a lawyer, like for an employment case, they have to sue for 1 year's wages. So there might be confusion about that. That's like, it doesn't mean they think the case will take 1 year, but it's like a standard that's used in court that you have to sue for 1 year's wages. If it takes 3 years, you win 3 years' wages. But so I'd look very carefully at what the wording of the contract is. So.
Okay. Moving on.
Yeah. Tsugi. Okay. Direct employment versus hakken. So this is really important. Like I said, hakken is not your friend. Okay. Dispatch contracts are not your friend, regardless of what the corporate media says. Both of these are rodo keiyaku. But remember that, so the questions you have to ask is, who is your employer and who is your boss? In a normal situation of direct employment, so let's say, for example, let's say you work for Shane or something like that. Shane would be your direct, there is direct employment. Shane is your employer and Shane is your boss. That's a normal direct employment situation. The responsibility is concentrated in the employer. With a hakken situation, it's bifurcated. So let's say Acme Dispatch Agency sends you to Shane to work. Okay. In that case, Acme Dispatcher is your employer, but not your boss, whereas Shane is your boss. In other words, where you work, you can get work orders from the boss there. But your employer and who pays your money is the dispatcher. And then the dispatcher and Shane would have a separate contract outside of that.
Okay.
So it's important to understand that dispatch relations with your boss and your employer are different companies, right?
Okay. So what about if your employer is then sort of saying directly to the worker, like, let's switch to a Gyomu Itaku contract?
You mean from dispatch?
No, from being direct hire or direct
direct hire to
Gyomu Itaku.
Gyomu Itaku. Yeah, say no. But I mean, one of the things is often, and we'll get to this in a second, but often it's a fixed term contract. And if they do it at the end of the fixed term, they have all the power and they can offer you whatever they want in principle. And so it's very difficult because you may not have much choice. So but it's very important, first of all, to understand that a Gyomu Itaku is a terrible contract. Even if they offer you more money, you have no rights in a labor law, no guaranteed paid leave, no protection against non-renewal or firing or anything like that. It's just nothing. You're just a business. The only protection you have is that to the end of the contract, both sides have to fulfill it. But it's like everything's arraigned against you. You have no right to, you don't get unemployment insurance, you don't get health and pension insurance. If there's an accident, you don't get roadside workplace accident insurance. So it's a really bad situation, but it's very good for employers because they can get away with anything.
So
as long as they pay what's in the contract.
Something that companies are trying to almost do ahead of the Shakahoken switch.
In order to get out of, because Shakahoken, the threshold is going down, which means more and more workers are going to be eligible for it, and companies want to avoid enrolling their workers. So a lot of companies are trying to push to Gyomu Itaku, because then, of course, there's no Shakahoken, there's no Koyohoken, there's no paid leave. I mean, they can give paid leave if they want, but they don't have to give paid leave at all. And they can change the contract the next year, and there's no, like, you can be non-renewed for zero reason, even if there is expectation. So it's really, really bad situation. But it's attractive. Sometimes companies offer a little bit more to lure people into this really bad situation. And, if you want to do it, fine, but just know that you have no more labor rights.
So kind of possibly jumping the gun here, because we're going to be talking about them later. But if you're currently on a Mukikoyo contract,
right, permanent open-ended,
your company sort of says, or you switch to a Gyomu Itaku contract, you are no longer Muki in the eyes.
You're not anything. You're not even employed. You've basically resigned or got fired. So if you're on a permanent employment and your boss says, "Hey, I'll pay you more money if you switch to Gyomu Itaku," know that your employment is ending and you're entering into a completely different relationship. In general, you should say no unless you don't want to work there anymore or something like that. And if they try to force you on it, they would have to fire you first, and then you can challenge the firing. So it's definitely a huge step down. So
okay. Anything further on?
I mean, it's really like ripe for all kinds of abuse, and employers and companies definitely abuse this system a lot. So we, of course, some language schools like GABA and NOVA, they also abuse this system. And one of the things about Gyomu Itaku you have to understand is, like, whereas in Hakken I said your boss is where you're dispatched to, but your employer is the Haken Gaisha. For Gyomitaka, there is no boss. They can't give you work orders. Now, in fact, they often do, but they can't legally. If they give you work orders every day, then it is a rodo keyaku, not Gyomitaka, even if it says Gyomitaka. So it's really important to understand, if it's Gyomitaka, they should not be giving you orders. They should not be telling you when and where to work, although they often do. So,
but with kind of what we said before, with like the finished product, kind of Gyomitaka,
like the ukiyo-e, right?
Yeah. So surely with that, there's some degree of expectation of, I want this done in this place. So the product would be there to a degree of.
Like if it's my kitchen, if I want my kitchen, a new kitchen, they can't build it like on the roof, right? Or they can't build it at their own studio or something like that. So so there are some reasonable things like that. But what we often see is schools like Nova or GABA, they actually have a lot of rules and a lot of instructions and a lot of details about time, place, and everything. And yet they claim it's Gyomitaka, like this, we're just outsourcing, which is important. Like if you're working, like Nova has both types. They have employment, teachers on employment, and teachers on Gyomitaka. But you have to understand, if you're on Gyomitaka working for Nova, you're not a Nova teacher. You're your own teacher. And they should not be giving you any kind of instructions about where, when to work, what to wear. And you theoretically, you should be able to even send your friend on a day that you don't want to work, because it's up to you, because you're a business. You're providing a service. The same with GABA teachers, right?
So could you argue that a company that only has Gyomitaka contracts is almost...
You mean like for the teachers, right?
Yeah.
It's rare they'd have only Gyomitaka for all their workers.
Yeah,
exactly. Almost impossible.
Yeah. Would that be arguably almost more legitimate than having both, or could you say it's almost like it's
no,
more,
I think it's less legitimate. Like having both is more natural, because think about it. If you're like, let's say you're a language school, right? Let's say you're GABA. Right?
Can I finish the point? Sorry, right. But like if you've got the mixture, some direct employment, some Gyomitaka, if they're both being done or being told to do kind of exactly the same job,
that's weird.
It's almost more of an egregious, like,
if they're being both ordered in the same way to the same degree, then it's obviously there's a contradiction there.
Like the bogus.
It's bogus outsourcing. Like one thing though I'd say is that if you're, let's say you're a language school, let's say you're GABA, or no, let's say you're Shane. So Shane recognizes the employment of his teachers and his counselors. Good for them. Okay, as of now. So but let's say Shane wanted to, what if like a storm hurt the Shane sign outside one of their schools, and they wanted to hire a company to fix it, right? Like in Japanese, say gyosha, like a company, or to fix it. That would make sense not to have an employee do that, because it's not their main business. So it makes sense for them to hire someone, and like, once you fix it, we'll give you this amount of money. Okay, great. And they sign a contract. That makes sense. And I think it's kind of legitimate.
So you've got a specialized.
Right. But if they have their teachers on Gyomitaka, if they do, did or do, that would be bizarre, because it's their main business. Like the idea of Gyomitaka outsourcing, you outsource stuff that you're not good at. So like, I hate to keep bringing up GABA, but GABA, like there is no such thing as a GABA teacher. Like people call them GABA teachers, and I bet a lot of the students think they're GABA teachers, but there's no such thing as a GABA teacher, because they outsource the teaching of English. Isn't that bizarre? An English language school that outsources English teaching. It's really bizarre. And that's my opinion. Like, I don't think your main operations should be Gyomitaka in any situation. So,
okay, cool.
But like, if you're a chip maker or something like that, like imagine if you're a chip maker, like a chip, fabricator, and you outsourced chip fabrication. That would look pretty sleazy, right?
Or
Like,
I'm the
what
greatest
the
swimmer in the
heck?
world, but I outsource my swimming to someone else.
Right, yeah, it's like so bizarre, right? So, okay, go ahead. Okay, now we're getting into direct hire. Contracts are getting better and better, but there's still a big problem. This is Rodo Keyaku and Yuki or Yuki Koyo. This is temporary. Now, it's often called fixed term employment. Now, that's correct because there's a fixed term, there's an end date on the contract. The most common is 1 year, but there's all kinds of others. There's 1 month, there's 3 months, 6 months, 2 years, 3 years. I prefer the expression temporary employment in order to underline how it lacks job security. So, and also I think it's more like easily accessible to say temporary. Like if you're on a fixed term contract, you're a temporary worker. You're not a dispatch worker, but you're a temporary. You're in a temporary position. It's really important to understand how little job security you have. In principle, at the end of a temporary contract, the employer has no obligation to renew your contract. Now, they can't refuse because of your gender, your nationality, your race, your creed, or anything like that. It can't be discriminatory, but they don't have to give you a reason. This is in principle, it's very important you understand. Like our lawyer, Keiko Kato sensei, she always says this, at the end of a fixed term contract, that's the end. The last day is the last day of your employment. That's why it's so bad. It's very, very difficult to fight if they refuse renewal. Now, they can't fire you in the middle of the contract without a damn good reason. But at the end of the contract, they don't need a reason. Now, there is an exception. And this is one thing that for these kind of contracts, you got to look at Labor Contract Act or Rodo Keyaku and look under them. The most important ones for our purposes, the most important articles are 18 and 19, Article 18 and Article 19. Do you know Article 18?
I have.
That's the one that
I've done very well at learning it and then forgetting it.
The 5-year rule.
Oh.
Do you want to explain it?
The 5-year rule?
Yeah, yeah.
Short summary?
Yeah.
Okay, so the 5-year rule is if you work continuously at a company for 5 years, although a under 6 months break is okay,
right,
during the employment, once you've reached your 5th year, you can then apply to.
So you have to go past 5 years.
Yeah.
You have to go past.
Okay.
Yeah.
Once you've gone past, so you're into your 5th year, isn't it?
No, into your 6th year.
Into your 6th year, sorry.
Yeah. I mean, this is assuming 1-year contracts.
Okay, yeah.
Yeah. What the law actually says, Article 18, is that if you're in a contract period that will take you beyond 5 years, then you can convert. Okay. Yeah. And I'll explain how to do that. So, so in other words, if you're in a 1-year contract and you're in your 5th year, you can't convert. And often employers will end at exactly 5 years so that you don't go over, so that you can never, take root, that you can never win permanent employment and then you're out. So this is one of the negative impacts of this law, which came into effect in 2013. So, but if you're on a 1-year contract in your 6th year, you can convert, and it means you're permanent as of the first day of your 7th year. Okay. And you touched upon the cooling off. The cooling off, if you're on 1-year contracts, the cooling off period is 6 months. If you're on a 1-year contract and then you have 6 months where you're not employed, then the clock goes back to 0.
Yeah.
But if it's less than 6 months, it doesn't. Now, if the contract period is less, then there's like a whole formula about it. The cooling off period could be shorter, but that's basically how it works.
Yeah.
So that's Article 18. And of course, it's very important. If you've already worked more than 5 years, or if you're in a contract that will take you over 5 years, definitely convert. There's no downside. You'll be permanent on the current conditions. Even if you started on really bad conditions and part-time and terrible contract, but you're employed continuously, and now you have great conditions, lock them in by converting to permanent employment. Okay. Now, the other one is Article 19. Article 19 of the Labor Contract Act says that if there's reason to expect renewal, then management cannot refuse to renew without a good reason. Okay? So if everyone is almost automatically renewed and there's very good reason to expect renewal, then you can claim that they have to have a reason to refuse renewal. Now, this is much weaker than permanent contracts, but it gives us something to fight with. Now, you should know that people who challenge non-renewals in court, 90% of those cases end up in the worker losing. That's how bad these contracts are. And my personal view is that yuki koyo, these yuki keiyaku, should only be applied if the work itself is yuki. It's like, let's say you're doing a film, like a Hollywood film, and it's going to take 1.5 years to produce. Then it kind of makes sense that the studio would sign you up for 1.5 years. I mean, of course, Japan makes films too. So yeah, the Japanese film studio too could sign you up for, let's say 1.5 years, because that's how long the film would take to make. And there's no reason for it to continue or to renew. In my opinion, those are the only legitimate times to use temporary contracts. However, they're everywhere. They're more and more, like the labor market is infested with them, especially for foreigners. I'd say for foreigners, probably in my experience, about 90% at least are on these fixed term temporary contracts with zero job security. So this is something, please read Article 18 and Article 19. Also, I want to, like Yuki and Muki is temporary versus permanent. This is often confused with part-time versus full-time. Part-time versus full-time is a completely different issue. That just means how many hours per week you work, okay? And there's no legal definition. Well, different laws have different definitions, but there's no general definition of what is full-time. The maximum in principle is 40 hours a week for stipulated work hours. But part-time could be anywhere from 1 hour a week to 20 hours a week. Part-time and full-time is a completely different issue from temporary, permanent, although most part-time contracts are also temporary, but it's important to distinguish these two things. I've heard many people use full-time as a synonym for permanent, and it's completely different thing. Okay, now, this was temporary contracts. Now we're going to the holy grail of contracts, of work contracts.
But first,
okay.
a question.
A question. First, a question.
Okay. So a good friend of ours.
Okay.
They say they've got a question from their student.
Okay.
So this student, she registered with a dispatch company and worked part-time at a warehouse. Her boss said to her, if you stop registering with the dispatch company and sign a Gyomutaka contract with us, we will pay you the money we used to pay the dispatch company.
Which is more, right?
Yeah, you will get paid more.
Yeah. Clever.
Sounds not bad.
Take out the middleman.
Yeah.
Or woman. Yeah. The middle person.
Is this a good deal? Is it better to be through a dispatch company than Gyomutaka?
Well, first of all, check your dispatch contract. Read it carefully and make sure there's no prohibition of that. There often is some kind of prohibition, maybe even the work rules of the dispatch company. There may be a prohibition of signing a contract with the dispatchee, the place to which you're dispatched, the hakensaki. So check that. Check at least the contract and preferably the work rules as well, the shugyo kisoku. And then I would say it's more likely that that company has an agreement with your dispatcher not to poach workers, but it might be employment only or something like that. The one thing you should know is that it's not a good deal in the sense that you'll be gyomitaku rather than rodo. As a dispatch worker, you're on a rodo keyaku. So remember, in my slide presentation today, you're going backwards. You'll get more money, but fewer rights. So if you're full-time, that means right now you should be in unemployment insurance and shakai hoken, health and pension. And under Gyomitaka, you cannot be in those things. Even if the company wants to put you in those things, they can't. So you'll lose those, and you'll lose all your labor rights except maybe trade union rights. But you'll definitely lose the right to paid leave, the right to, protection from firing and stuff like that. So be very careful about it. You can do it if you want, but just know what you're doing.
So you said about like one of the main points is check your dispatch company's contract and the work rules.
Yes.
So
like the terms of the registration or something like that. Yeah.
If this worker was to kind of do this, would they also be the one who would be suffering the consequences for anything that, like, from the company kind of poaching them from the dispatch company?
Yeah, my first instinct, I'm not a lawyer, just want to make that clear, I'm not a lawyer, but my first instinct would be that the company that's trying to pull you away is more at risk of maybe getting sued for damages, my guess, okay?
Oh, okay.
But check your contract. Now, in any case, if anybody sues you or the company, they have to prove some violation and prove the financial damages and how much those financial damages are. And it's not always that easy. And it's especially difficult against a worker. Like workers' freedom is pretty well protected. So, but definitely check your contract very carefully. Read every term of your contract in case there's something in there about that. And if it's like the company that's trying to headhunt you surely has a contract with your dispatch agency, I would recommend they look at their contract, because it's very likely something in there about don't poach our workers, but that's their problem, not your problem. If they're sued, you're not going to be responsible for them being sued. So check, you're responsible for what you signed. The contract that you signed and agreed to, that's what you're responsible for.
Okay. Are there, like, this also seems like it runs the risk of the worker potentially being maybe blacklisted. Is there anything like protections from blacklisting in Japan, or
not that I know of, but
with
to be honest, in my experience, I've seen no evidence that any blacklist ever exists. I think companies are too busy or too lazy to actually go around to help their rivals. Like, do they want to protect their rivals from their annoying workers? Like, I mean, I've just never seen it. Like, I've seen, workers create all kinds of trouble for their employer, and then later go and get a great job somewhere else. I mean, like we have a member whose initials are AAA. I don't know if I should say his name, but he causes all kinds of trouble for everybody, and he got a great job. So I really don't see any evidence that these blacklists actually exist. The worst that can happen is you put on your resume, I worked for Shane, and then a prospective employer will call Shane, and Shane will say, yeah, he was a pain in the neck. He caused all kinds of trouble.
But legally, they can't do that, can they?
Legally, they can't, but if it's a phone call, it's like they can't do something to interfere with future job prospects, but they could probably get away with it. But even then, people, in my experience, they usually land on their feet and often get a better job. So I wouldn't worry about it too much.
Okay.
But I wouldn't worry about blacklists too much. I've honestly never seen it.
Okay. So in regards to the Haken Gyomutaku.
Haken and Gyomitaku are different things. Yeah.
Isn't this, we've got a question. Isn't this abrogation of freedom of contract and basically indentured labor?
Abrogation of whose freedom? Like, I mean, I agree it's kind of like indentured labor because they were like, the person agreed to it, right? Yeah. I mean, it's intermediary exploitation, like Article 6 says. So yeah, I'm opposed to it, but the way the law sees it now, the way the courts will see it is that, well, you signed the contract with the dispatch agency and this is what it said and they followed it. So it's your responsibility.
Yeah.
You agreed to be an indentured servant. So the same with Yuki and all that. So
the follow-up to this was, moreover, if your contract expires after 1 year and you then make a new contract with the company you're working at, how can this be a breach of contract if it has expired?
Yeah, I mean, that's a good point. And I personally agree with that line of thinking. However, the courts don't. If your contract says you will not, for 2 years after your employment here, sign a contract with, Acme Factory or something like that, the courts will accept that you really shouldn't do it. But again, if your dispatcher sues you, they have to show not only that you violated the contract, but that it caused them financial damage and how much. And that's going to be very difficult. Usually companies don't sue workers, even if stuff like that happens. That's no guarantee. And I'm not saying it's right to do that, but they usually don't. I mean, I've almost never seen it. Often your contract will say, if you resign, you have to give a month's notice, right?
Or 2 months notice.
Or 2 months, some crazy stuff like 2 months notice, right? You can, in reality, you can walk off the job. The civil code says you have to give 2 weeks, but even if you give a week or a day or just walk out, the reality is your employer is not going to sue you. I mean, I can't guarantee that, but in hundreds and hundreds of cases, I've never seen a company, because the burden for them is too much. They have to pay a lot of money to a lawyer. They have to somehow prove that you walking out caused financial damage because this person canceled the contract and this is how much money they had to pay back or something like that. And it's so much trouble. And by the time they won it, they would have spent more on legal fees. Remember, corporate lawyers are much more expensive than our lawyers, right? So they just don't do it. Again, I cannot guarantee that, but they don't do it. So
I feel like we should be holding for something. Thank you, Buski and Kato Sensei.
Yeah, I know. Yeah, our lawyers are so wonderful that they give us rates that are a fraction of what management pays. So, yeah, and the reality is, and also Labor Standards Act explicitly says that if you're working under conditions that are different from promised, you can walk out with no notice. And that, so if that's the case, and that often is the case, you can walk out. But at the most, feel that you should give 2 weeks notice and try to give, a reasonable amount. So,
cool. Okay.
Okay, should we go to the Holy Grail?
The finale.
The finale. Da, 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 da. This is the contract you want. Go ahead. Tsugi.
Nah. Okay, there we go.
There you go. Rodo Keyaku Muki Koyo. This is permanent, open-ended employment contract. You have arrived at the promised land. This is a contract with no end date. This is still the contract the majority of workers in Japan have with their employers. Believe it or not, they're still hanging on to a majority. It's been eroded and more contracts are going the wrong direction. But still, this is the normal contract, and it's often verbal. A contract with no particular end date. And that means that Article 16 of Labor Contract Act applies. And Article 16 basically says you can't fire someone without a damn good reason. And the specific wording is a reasonable, objective reason that is sufficient according to social norms, okay? And it's a very high bar. You can't fire someone because they're, even if they're just a little bit bad at their job, they have to be really bad at their job. And then all sorts of questions come up. Well, why did you hire them in the first place? Why didn't you fire them 2 years ago? Why didn't you, there's all kinds of things that they have to overcome. There's 3 types of firing, 3 main types. One is an ordinary firing, which you can only do if they have extremely bad performance. And there's no expectation for improvement. Another is called the chokai kaiko, which is a disciplinary dismissal. And that's something really serious, like commit a crime or something like that, or steal money from the company or something like that. And then there's a seiri kaiko, which is a redundancy type of firing, like downsizing. And even the redundancy is not that simple. You can't just say we want to save money. The employer has to show that basically the survival of the company depends on them firing people. And then there's rules about how they go about doing it. They have to try to avoid it. They have to explain everything. They have to have very good reasons about who they choose to fire and like that. So it's not easy to fire someone once they're on an employment contract. So from the worker's point of view, this is job security. This is what you want in all situations. If you have any negotiating power as an individual, demand this. And if you don't, of course, unionize, and we demand it as a union. This is the basis upon everything else. If you don't have this, if you cause trouble, if you demand your rights, they can refuse to renew your fixed term contract. So it's very important to get this. Okay. So that's my presentation. So any questions?
This last one felt like the shortest one.
I know, because there's not much to say about it. It's great. It's really good. So there's especially in Japan, I think it's, like in the United States, I don't know much about other countries, but in the United States, it depends on the state. Labor laws are different by state. And there's some states that are called right to work, which is almost the opposite, but the meaning. But in those states, they have what's called employment at will. There's many states that have employment at will, or in Japanese, zui koyo, right? And employment at will is that basically we can fire anyone we want unless they're protected under discrimination laws, right? So in Japan, that's kind of how the renewal process is, unless it's a discriminatory reason. You can't refuse renewal because of the person's race or creed or nationality or union activity or striking or anything like that. But for permanent employment, you have to have a good reason. It's not just it can't be a discriminatory reason, you have to have a damn good reason. And Japan is famous or infamous for employers that it's hard to fire people.
So with kind of this, we've focused mainly on it's very difficult to fire someone.
They still do, but
yeah. But what about the other ways that a company can mess with the employer? Or sorry, the company can mess with the employee.
Yeah.
So for example,
there are many ways, yeah.
Like you said, firing someone because they're bad at their job, you can't do.
Yeah, they have to be really bad. It's just, yeah.
But what about things like making
and there has to be no way to no sign of improvement, like when you try to get them to improve.
Yeah. So what about then making things that are kind of performance related? So you're giving them sort of almost impossible targets.
Yeah. Well, they do that. It's like when a company wants to fire a permanent employee, they have a system and they have a playbook. And in that playbook, there's a thing called the Performance Improvement Plan or Performance Improvement Program. It's called PIP. Sounds great. Wow, improve the performance of the workers, right? It's not. The only purpose is to build a case for firing the employee. So they go to a lot of trouble. Okay, you got to do this, 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 and this by December, and it's like super hard, and they don't ask anyone else, and it's ridiculous. They're going to make it seem like it's just a normal part of your job, and then no matter what you do, they'll say that you messed it up and didn't do it right, like almost right. And we have strategies for how to deal with that when that happens. And if you have cases, if you're getting a PIP, please contact us and we'll give you a strategy. Yeah. Another thing, what they do is they hire a consultant, and this has actually happened to us at Lycée recently. They hire a consultant. And whenever you hear the word consultant, it's like a warning signal. You should hear your antennas should go up. Consultant, what they do is they come in under the guise of fixing problems at your workplace, and they pay them a lot of money. What they're often actually doing is helping management find out what's really going on to find a case to fire their employees. And so be very wary of consultants. So yeah, so employers have their strategy about how to get rid of workers that they don't like, either because they're unionizing or because they just don't like them or something like that. So we have to take defensive measures, and of course, making unionizing the workplace offers a lot of protection, because then they can't fire everyone, and you have a lot more strength. Very important to protect you and your coworkers. Yeah.
So if you're suddenly put on a PIP, would it be an idea to, again, straight away talk to your coworkers, like, have you had this kind of thing?
Yeah. Always talk to your coworkers. Yeah. If you getting along with your coworkers is a great defense. And of course, contact us and contact your case officer, or talk to your workers. You should try to unionize them before you get the PIP, because the PIP is like a stigma. Like, as soon as you get the PIP, I think everyone knows that the company wants to fire you. So recruit before the PIP. And then when you get the PIP, we deal with it as a union. So, and there are ways to deal with it. Like, one of the things I always say is that if they say, okay, you have to finish these 5 projects by December, and you could only do 1, you have to say it. Don't say, I'll do it, and then don't do it. It's much better to say, by December, I can do this program only. This project, sorry, I can only do this project. It's very important. They can't, it's hard to fire someone because they're slow in the management's eyes. You know what I mean? Be realistic about your pace, and especially within your stipulated work hours, and then do the best you can, and do what you say you're going to do. So you have to be able to judge yourself. How many projects can I do by December? So, okay.
Okay. So, like, there's that way of kind of screwing. The other things, though, is what they make another way for them to get rid of the workers would be what creates a toxic environment.
Yeah, like harassment, something like that.
Yeah, or not even going so far as that, like implementing maybe a performance-related pay system where if you're not hitting targets, you get deducted, and so people are almost forced out and forced to resign.
Yeah, performance pay systems are almost never about actual performance. They're about dividing workers and controlling workers. So so they can use these systems. If they don't like someone, of course, they can give you lower grades on the performance. It's always subjective. And usually management doesn't know what they're judging. You know what I mean? They're people who don't know the job as well as the workers, and they're judging who's better, who's worse, and like that. Performance pay systems are not good for workers. They're not good for performance, in my opinion. So be very, very wary of that. And that's definitely a way that management can control workers and also push out the ones they don't like, or the ones that stand up or talk back. Right?
So when a worker resigns rather than being fired, they don't get the benefits that they would get from being fired, would they?
You mean like unemployment or something?
Yeah, or like Hello Work.
Yeah, like Hello Work provides employment benefits, and if you're fired, you can, or non-renewed, you can get them right away. But if you resign of your own volition, you have to wait 3 months. So that's one thing. Yeah.
Okay. Question. Very good friend of the show. Let me get through it all before. Sorry. I'm on a fixed term contract at a university. There are 2 points of review typical of a university for being offered employment further for regular faculty. I have done quite well at my job, but the terms of review are not clear, and my boss has ignored many emails. This year, I will have my first review. However, I have been very outspoken about safety. I expect trouble or an ad hoc reason for giving a poor review on something, as the review is explicitly for permanent employment if I pass. How can I or any academic prepare for such a situation? I have been directly told verbally my current job will have a good chance of being permanent. This is what the choice is supposedly based upon.
So it sounds like you're, if I know who it is, I think you're in your 5th year, and yes, if you pass this, you get permanent. So I would say, like, do whatever they say until you get permanent, and especially if you're this close to it, be very careful and kind of, like, kiss their feet until you get past that hump, I think, right?
So don't take unnecessary risks.
Yeah, don't take any risks now until afterwards, and then and if you get a bad review, don't take it personally. It's often BS. Talk to your case officer, talk to someone in the union about how to respond. Is very important how you respond to it. And even if it's all nonsense, don't get into a big fight at the meeting or something like that. You just say the facts as you understand them, and then talk to us, and then we'll help you craft a response. So.
Cool. Any other questions?
Are there any?
Well, if you've got any more questions, we are.
Yeah. Or comments.
Or comments.
If you like my tie.
Can't see it behind.
It's my tie? What? Yeah, you can see it.
It's not good. This feels like a very failed comedy act now.
No silliness in Tozen.
No Tozen in the silliness.
Mm-hmm.
So do you have any other extra comments you'd like to make about all of this?
Yeah, I mean, like, every time I do these discussions on labor stuff, it all comes back to unionizing or not. Like, the answer to almost every labor issue is unionizing early and a lot, and really reaching out to protect your coworkers. It's all about solidarity. Like, management wants to keep us divided as much as possible by different job types, different contract types, different wages, different performance. We should go in the opposite direction and bring, and build solidarity. Building solidarity is so crucial to fighting back. So, I mean, what do you expect a union guy to say? But yeah.
We've got 2 comments.
Okay.
One, you look great, Lewis.
Really?
Yeah. I think it's.
You didn't want to report that, did you?
It's your second friend.
My second friend. What?
We've got like 2 friends, right?
In the whole world.
And the second point is your tie's off center.
Really?
8 out of 10.
8 out of 10. Shoot. Okay.
Yeah. Okay. So, what about then negotiating your contract? We haven't really touched on that as much today.
Well, the reality is, unless you're like one of the greatest soccer players in Japan, you're not going to have much strength as a negotiator. Like, the 99% of workers have no negotiating power. It's take it or leave it. A company says, this is our contract, take it or leave it. If you leave it, we'll offer it to the next worker, right? So you have very little individual negotiating power. If you work with your coworkers together and you form a united, yeah, of course, if you unionize as a united front, even if you're on Gilmataka, by the way, and you make decisions together and you support each other really strongly, then you have negotiating power. Otherwise, you've got nothing.
Because isn't one of the early articles of Labour Standards Act is a contract agreed upon by both the worker and company? Yeah,
I mean, technically, it is a negotiation. Like, a company offers you something, you can say yes, you can say no, you can say, I would accept it if you change this, but then they'll probably say, oh, get lost, right? So technically, it's a negotiation, and then there's an agreement between the worker and the company, right? Yeah.
And what about when you're in Mookie and your company tries to renegotiate your contract, or if you've been getting renewals on sort of the same contract, and then later down the line, like, they offer sort of like another contract, but it's a degradation.
Yeah, well, with Mookie, if you're already Mookie and they say, here, we have this new contract, it's got more work hours, but don't worry about it. You have to understand that as a proposal. You don't have to sign it. A lot of employers make people think they have to sign a new type of contract. Even it might even be fixed term. So you might be on Mookie in permanent employment, and they might offer you a higher wages, but 1 year, because they don't like you being permanent or they want to get rid of you. So if you're willing to accept the loss of job security for the higher wages, go ahead. But you have to understand it's a proposal. They cannot order you to sign a contract. We have this problem a lot of employers. They think they can give a work order for someone to sign a contract or an addendum or a change or something like that. That's nonsense. It's a proposal. Now, the difficulty comes with when you hit the 5 year, and we had this issue with French Institute, is that at the 5 year mark, some employers purposely offer you a lower contract for the 6th contract because they want to make sure that they're not stuck with you on the higher contract. So you're stuck with the position. Okay, so do I challenge that based on Article 19 of Labor Contract Act, or do I just sign it and accept the lower pay? It's a really painful decision, because if you fight, you could lose everything. But if you accept it, you might keep your job and it'll be permanent, but it'll be on lower conditions. And so these are the things that happen. Like with fixed term contract, let's say you work 1 year, the next year they could offer half the salary, and you're basically screwed, because what are you going to do? You can say no, and then you'll be out of a job. So it's very, very difficult. And ideally, like, everyone is in the union and everyone refuses any kind of fixed term contract, right? But that's something we have to build towards. We have to build a movement to really push back, because you know what? Business, they have a movement. They have a Japan Business Federation, Keidanren. They have solidarity, and they are pushing in this terrible direction. So we've got to build a movement to push back.
Yeah. Oh, what was it? Those in power are often more united than
yeah. We have to learn from the enemy. We're very, very united, right?
Yeah. Okay. Yeah. Any further questions? Okay. Give it a few seconds, because we're still
they might be writing something or something like that. So yeah.
So
they can't talk there, can they?
They've got the chat.
No, but they can't.
Directly.
Yeah. Maybe we should arrange it sometime where we take calls or something.
Yeah. Give out our line. Oh, that would be
fun.
So as of now, we don't have a planned next Tozen Daigaku. However, we are always open to suggestions and what would you like to see in the next Tozen Daigakus. We're going to be planning our next or upcoming calendar for the next year or so. So yeah, email me at pr.tozen@gmail.com, and with any ideas, suggestions, or comments about the videos. Yeah, and it'll help us with getting the new ones. Okay, one more question. Honestly, what security are we talking about here? Management still screws up the open-ended permanent employees and fire them unfairly. It happens a lot.
Right. Well, that's why we need a union to fight back. And I think people know that one of our main locals, they fired someone and the union fought back. We got a financial settlement, although, if we can get the union even stronger, we can sometimes overturn the firing. And there's also the court process. So we have overturned firings in court where the worker went back to work, including all the back pay. If we go all the way to the court, or if we can get the worker's job back, that's a huge financial penalty for the company because they have to pay all the back wages. So if we fight for 2 or 3 years and then win, suddenly the company has to pay 2 or 3 years of wages, which is, you know, many millions of yen. So it is an uphill battle, but that's why we want every workplace unionized, and it's the one way that we can really fight back. So, hey, the company can't do anything without its employees. So the employees are the company.
Well, half of showing solidarity is showing up.
Yeah, just show up, come to union meetings, come to stuff, and makes a huge difference. And I honestly think Tozen Union has the best members. Like, I'm very, very proud of our members. We have so many active members who show such incredible solidarity.
Okay, so it's almost 4:30. Should we bring this to a close?
Yeah, sure.
Well,
it's a fixed term. So. Sadly, Tozen Daigaku is in little fixed terms. But.
Join us for more non-jokes next time.
Okay. Yeah.
Okay.
Everybody.
Thank you, everybody, for joining us today, and we will see you hopefully next month.
Yeah.
Brilliant. See you soon.
See you soon. Bye-bye.
Goodbye from me.
Okay.
Goodbye. Okay,
Goodbye.
no goodbye from you.
Goodbye. Goodbye. Goodbye.
Thank
Goodbye,
you.
everybody. Thank you very much.
Yeah.
Tozen Da.
Tozen Da.
All right. Oh, were you waiting?
Yeah, like 1 minute.
Yeah,
Okay.
outside.
Timing was unbelievable, right?